Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today, we're going to have a conversation about a recent opinion from the Court of Appeals for the Armed Forces. Please note that these episodes may contain facts and circumstances surrounding criminal trials. Listener discretion is advised.
All rise. Hear ye, hear ye, hear ye. The Honorable United States Court of Appeals of the Armed Forces is now open and in session. God save the United States of America and this honorable.
Welcome to another edition of CAAF Chats, brought to you by the Academic Department Crim Law here at TJAGLIX. Today we are going to be discussing United States v. Tapp and United States v. Armstrong, two recently published CAAF opinions. Today we've got Major Dustin Morgan with me, and then some of you listeners out there will miss Colonel Seagraves because he has moved on to greener pastures, as many of you have found, but we found a wonderful replacement, a extern First Lieutenant Jack Parker. Jack, welcome.
Thank you. It's nice to be here.
And it's my understanding you are doing an externship here at TJAGLIX.
I am, yes.
All right. Well, glad you could be here with us to help listeners understand these two cases. Why don't you go ahead and get us started, and let's talk about the facts of both of these cases.
Yeah, so we'll kick it off with the facts from United States versus Tapp. A pretty gruesome set of facts for this case. Essentially, in July of 2018, Tapp and another Marine simultaneously sexually assaulted an intoxicated 16-year-old girl in their barracks room, leaving her with several severe injuries. After a 6-day trial, Tapp was convicted at General Court-Martial of sexual assault. Tapp was sentenced to a number of penalties, most notably 3 years imprisonment. Immediately following the trial, the judge held an impromptu ex parte session with trial counsel where he criticized the trial counsel's performance, namely because the trial counsel only had asked for 11 years confinement. Trial counsel notified the defense of this ex parte session, to which the defense counsel responded by attempting to disqualify the military judge from further proceedings. And at this point, the judge decided to recuse himself despite denying any bias or partiality in the case. Thereafter, a different military judge, Colonel Woodard, was assigned to the case, who denied the defense's motion, concluding that the rulings during and after the trial did not display any actual or apparent bias against Tapp. Colonel Woodard further noted that even if the judge was disqualified, the judge's comments did not even warrant a remedy under Liljeburg, a Supreme Court case. CAAF granted review to determine whether Tapp was deprived of his right to an impartial judge.
Awesome. And talk to me about United States versus Armstrong now.
Yeah, so Armstrong, a very similar case. Armstrong, during Armstrong's general court-martial, the defense asked the military judge to recuse herself due to apparent bias. The military judge denied the motion, and Armstrong was subsequently convicted of sexual assault. Armstrong was sentenced to 7 years of confinement, a reprimand, reduction to E1, forfeiture of all pay, and a dishonorable discharge. The CCA affirmed this finding. However, upon looking at some of the exchanges on the record and in the audio from the trial between the military judge and defense counsel, CAAF granted review on the question as to whether or not the military judge's departure from impartiality deprived Armstrong of his right to a fair trial.
So in both cases, we're talking about disqualifying a military judge based upon conduct that occurred during the trial. What did CAAF ultimately do with United States versus Tapp and United States versus Armstrong?
Yeah, in Tapp, Judge Olson, writing for the court, held that there was an insufficient basis to find that Colonel Woodard abused his discretion when he determined that relief was not warranted in the case. Okay. As for Armstrong, Judge Johnson, writing for the court, held that the military judge's impartiality could not be questioned and that Armstrong was not denied of his right to a fair trial.
Major Morgan, what's the baseline law that we're looking at here?
So really, it's two different questions. So whenever you have a judicial disqualification issue, the first baseline question is whether or not the military judge should be disqualified. And, there are rules for court-martial for that. So as always, you kind of look to the book first. So RCM 902 talks about judicial disqualification. So specifically from that rule, a military judge shall disqualify himself or herself in any proceeding that the military judge's impartiality might reasonably be questioned. So very broad understanding of what would allow for a disqualification. It's even if it could be questioned, not if they're in fact impartial, it's whether it could be questioned or not. So after you make that determination, you then go to the test that Jack mentioned under Liljeburg. So there's some question about whether it's Liljeburg or Liljeburg, because I heard an oral argument for both these cases. It pronounced two ways, but I learned it Liljeburg, so that's what I'm going to say. So if there are any commenters that want to question my pronunciation, that's fine. I understand it. It's an open question. So under Liljeburg, you're looking at prejudice, because as we've seen time and time and time again in CAAF cases, it's not enough to say that you win based on a legal principle. You have to show how it prejudiced the individual accused. And the test for that for judicial disqualification is Liljeburg. So here you're looking at three separate questions. So first, it's the risk of injustice to the parties, and then it's risk of injustice to other cases, to the overall system itself. And then finally, an interesting question, it's the risk of undermining the public's confidence in the judicial process. And you can't just talk about the specifics only surrounding this issue. It's what if the public was completely informed of all the surrounding circumstances of the court-martial, of the case, would they lose their confidence and ability in the military justice system as a whole? So that's kind of what you're looking at when you talk about disqualification cases.
Now, just going back to Tapp a little bit to kind of compare the two cases. Both cases are panel cases, is that my understanding?
That's right. Tapp and Armstrong are both decided by a panel.
And most of the issues in the United States versus Tapp occurred outside the panel's presence.
I mean, it's after the case occurred, so...
And I know there was some during the motions that were filed out of time in Tapp that received some blowback, but when the judge did the analysis to determine whether the trial judge should have been disqualified, he found that those rulings were very well reasoned and they didn't appear to show any type of bias.
Yeah, that's right. And it's interesting to note that those would have happened in an Article 39A session as well, so outside the presence of the panel. So no indication that any of the issues that the accused takes issue with during his appeal are happening in front of the fact finder or the people that sentence him inevitably.
So what's two cases that came out pretty close in time, deal with similar types of legal principles. What's somebody from the field, at least from the legal law perspective, take away from these cases?
Yeah, it's interesting. So as a practitioner, it's a weird position to be in, to be challenging the partiality of a judge, especially for junior practitioners. It's a tough ask to get up and ask the judge to recuse themselves because it's kind of an intimidating thing to do. They're the ones that have dominion and control over the courtroom. But if you're going to take anything from Tapp and Armstrong, it's that you need to establish a rock-solid record of how some sort of injustice is being done to your specific client if you feel that there's any kind of impartiality. Or if you're a government counsel and you feel the judge is being impartial to you, how it's impacting your ability to try your case. You have to have some ability to build the record on that, because while it's three-pronged and the last prong looks at the system overall, the CAAF hung its hat in both instances on the fact that the judges in both cases seem to make no ruling that's adverse to the accused in either case. They looked at the record in total. They looked at all the objections that counsel made. They look at the motions that were filed. They look at the trial as a whole, and they find no indication that the judge was being unfair given the totality of the circumstances. And without that, you're probably not going to win in a Liljeburg type prejudice analysis.
And I think it's also important to note that even making a note of something that happened without making an impartiality challenge in real time is part of building the record. Kind of like if you've got a panel member that's continuously falling asleep or not paying attention, you may not say, hey, I want to challenge this panel member right now, but you do during a 39A hey, I want to make a note that, panel member X is doing this and doing that. Can I get an instruction for the whole panel? So you kind of build the record as you go. I guess my takeaway from the field, too, is these are, again, court-martials are full contact sports. They're highly emotional. The facts are never good for anybody, and there's a lot of strong feelings about how things should turn out, which is why somebody on both trial teams or even judges, sometimes the best thing to do is take a step back and to get a good asthma check before you do say or do something that you may regret.
Yeah, and I think that last point's like really interesting, because making a note of a judge's hostile tone or the way that they're approaching you is tough to do. Like, you'd have to stand up on the record and be like, I'd just like to point out that the tone that you spoke to me with, Your Honor, the last time, like really difficult to do. And that's not going to be enough even, because in both cases, the CAAF cites the Supreme Court, Litecki versus United States, and they talk about judicial, and I'm quoting from the opinion, judicial remarks during the course of trial that are critical or disapproving of or even hostile to counsel, the parties, or their cases ordinarily do not support a bias or partiality challenge. Yep. So it's going to have to be something more than that. And you're going to have to show that it didn't happen, that it happened more than once, that it wasn't an isolated incident. And that's very tough to do. I know time and time again we're talking about building a record to make sure that you have an argument on appeal. I mean, as always, the best thing to do is to win at trial.
And it's also, you bring up another good point, is also when you're a counsel and you're potentially, in your mind, being subjected to somebody that potentially you are thinking is treating you unfair, to understand the basic case law behind some of this, to understand that, like, hey, this isn't a winning issue for you, and you need to focus on actually the trial itself, the cross-examination, the arguments that you make, instead of getting wrapped up an emotional back and forth with the judge and lose focus on really what's important. Any last final comments on the case, Major Morgan?
Yeah, so getting to that and getting to a place where you're actually going to have an issue where disqualification is remedied. I mean, so they cite to a case in both of these instances, Quintanilla from 2002. And so they talk about it either being judicial or extrajudicial. So if the judge is doing something to judicial function, it's going to be hard to get there. In Quintanilla, the judge got into a fight with a witness outside the courtroom. Okay, much easier in that instance.
Sounds like it might be reasonably questioned.
Much easier in that instance. I mean, Quintanilla is, if you have that, guys, you're going to win. Congratulations. But absent that, it's going to be real hard, because if you look at Quintanilla and Butcher, Rudimetkin, like some of the big issues where CAAF's jumped into judicial disqualification, it's a high hurdle to meet. Like, that's the big takeaway.
Okay. Well, thank you, Major Morgan. First Lieutenant Jack Parker, are you ready to jump in and build a record?
I think so.
How long have you? So you're a 3L. Talk to me a little bit about your background here.
Yes, yeah, I'm a 3L next door at UVA Law. I came to Virginia via the Army JAG Corps' Education Delay Program, which allowed me to commission out of undergrad, take some time on the IRR while I get my JD, and then hopefully start working with the JAG Corps after graduating.
And you're doing an externship here for about a month?
I am, yes.
And how have you been liking things?
It's been great. It's especially working within the crim law department. It's been really interesting to dive headfirst into some of these CAAF cases and start to get understanding of the court-martial process.
Awesome. Well, we look forward to having you in our Corps very soon as you look to graduate next spring.
Yeah, thank you, sir.
Awesome. All right. Well, that, I think, wraps up this edition of Criminal Law CAAF Chats. That's United States versus Armstrong and United States versus Tapp. As always, thank you for listening, and reach out to us with any questions or comments.
And Colonel Seagraves, if you have any questions about the law, James and I are here for you. Just give us a call.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General's Corps, the Department of the Army, or the Department of Defense.
Court thanks counsel for both sides, and the court will stand in recess until further order of the court.